Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers in the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy. Hi, today I have with me two very special guests, which is kind of unusual for our podcast. I have Shalini Nanjia, who is a family law attorney, and I have Carrie Rosenblum, who works in the mental health professional circuit. And the two of them have been talking a lot about children and the differences between children and the legal process and children and the emotional needs going through divorce. And we thought it would be really fun for them to kind of have their discussion on the podcast and hear what they have to say. So I want to thank you and welcome both of you for joining me.
Thanks,
Carrie.
So how are we starting off?
Well, as you mentioned, Carrie and I, and this is going to be tricky because you're both Carries, but Carrie Rosenblum and I do spend a lot of time talking about divorce and children. And today we thought we would talk about how you bridge the gap between kind of the legal and emotional, especially when you're determining parenting time for children in a divorce case, and how you can kind of advocate for children beyond what the court looks at, which are the best interest factors, kind of discussing the legal versus the emotional concepts. And in general, our conclusion is, why people who are in this situation to try to avoid court if they can. At its root, divorce is a legal process. It handles the financial issues and the family issues, the children issues. The financial issues can often be more straightforward to handle in court, although even there, I would recommend collaborative or mediation. In general, staying out of court is always better. However, with financial issues, it's a little bit more straightforward. There's sometimes formulas, there's black and white numbers you're dealing with, and at the end of the process, there's some finality. But when you're dealing with children and families in a divorce, it's a bit of a different animal because the family is still a family. And we typically run into like three lanes or three categories of families. I mean, the first one, the parents understand that their marriage didn't work and that's done, but they do know how to, or they figure out how to kind of cooperatively co-parent their children. And often these are the people who, I may be dealing with, but sometimes Carrie Rosenblum doesn't even deal with because they kind of figure it out on their own. Then on the other end, you have the very high conflict cases. These are parents who just are not going to be able to resolve things without court involvement. And it may be issues of, physical abuse of the child. You have drug addiction issues. And I think the court is equipped to put in safeguards in those kinds of scenarios. But then you have kind of the middle lane, which is a lot of families that we deal with, which is a lot of gray because there is some level of dysfunction. And at least one or hopefully both of the parents is still trying to maybe work through things, but they may need assistance along the way. And there's a lot of different avenues for that. But really, these are the families that we see a lot, and Carrie works with a lot as well, where we're trying to kind of come up with better ways to deal with families and children. And it can be done very differently if you're going through court versus not going through court. And I think Carrie does a good job of trying to help educate people on that.
I want to ask a question. When you talk about difficult families who may have abuse or addiction, are you saying they have to go through the court process or they could still work it out on their own if they're capable of doing that?
Well, certainly there are families that have some of those higher level of issues to deal with. They do work it out. So I don't mean to say that they have to go to court, but there may be issues that make it impossible to sit down and actually do outside of court. And so I just was drawing the distinction that there are some cases that may ultimately just need to go to court. But yes, you have families of all types of issues who do sometimes work it out without going to court.
And court might mean just talking to, I don't know, someone in the court, not necessarily a judge, making decisions, correct? Or filing some kind of motions or.
Yeah, I guess it's important to note that when I say going to court, that you're right, that can involve a lot of different things, because in the family courts, it's structured. I mean, obviously the judge, everybody knows that the judge is kind of like the ultimate person making the decisions in your case. But, we say that over 95% of cases settle somewhere along the way. So really, there's a lot of people who are working outside the court, but you may go to court to file motions. You may go, the friend of the court is a concept here in Michigan where it's an arm of the court that handles only the custody, parenting time, and child support issues. And we have caseworkers there. We have people who are called referees, who they don't make decisions like a judge. They can make legal recommendations, but they do, have hearings. They do listen to testimony and evidence. They might interview the children. So you might have involvement with some level of court in your case. But when we talk about going to court, we're often talking about going and having a trial in your divorce case, which that is kind of that small percentage of people that they end up having to have a trial to determine all the issues in their divorce, right? So that's a small percentage of people. But in all those kind of steps that I talked about, the less I feel that you have to involve the court, the better. And that's some of what Carrie and I wanted to talk about and highlight for people, which is why. Why is it better for your family to try and work it out outside that system?
Wonderful. Thank you for
Yeah, I
explaining.
mean, I think like the concept of marriage is actually a legal relationship, and the concept of divorce is actually a dissolution of that legal relationship. So the court has to both approve the marriage legally, marriage certificate, and then approve the divorce legally. And there are requirements that the court will look at, basically financially and in terms of custody, that allow you to get sort of a legal divorce. And I think what we're focusing on is the path to those steps, and which parts are best in control of the families and which parts are required by the court. And I think the way I look at it is that divorce is not really the end of anything. It's not the end of your family. It's really a very, very thoughtful restructuring of your family, where you're going from a single household family with two parents into a dual household family, also with two parents, but the children now have independent relationships with each parent. And so, the most thoughtful sort of way to enter the concept of divorce is, how do I want to restructure my family? Some families, per Shalini's distinction, are coming from incredible dysfunction. And the restructuring would be an opportunity to say, okay, how do we reorganize this family so people can function better? And some have moderate dysfunction where it's much easier to look at the roles and the responsibilities that each parent will have after divorce. And so the most important thing for families to realize, though, is that these relationships don't end. They just shift. It's kind of like taking one company and breaking it into two. They still have to perform the basic function. You're still creating or producing, or that's good or service that you're creating or producing. But now you say, okay, how do we take the people who were formerly employed by this one company and give them the opportunity to do these jobs even better in the next company? And so it is, and that's really hard to do when you're trying to end a relationship, is think about, where do we want to sit together in our children's graduation? And, do we both want to be present right after the birth of our grandchildren? And when you're really thinking about the fact that a lot of people think, I could just get to 18. No, 18 is just where you have legal requirements, but you are a family forever. And so I think that oftentimes the needs of the families distinguish in terms of how they're processed and how they're configured from what the court looks at. And the court has these very well delineated sort of 12 factors that they do the best they can, but the court is a finder of fact and not a finder of emotion. And so You know, the restructuring aspect is something that nobody knows your family better than you do. You just might not agree on it. And that might be where the court becomes more involved. You know, Shalini, you want to share a little bit about the sort of granular aspects of the 12 factors? Because once you relinquish control and say to yourselves, we just aren't getting along, we don't see eye to eye. The idea of substance use or mental health issues is that they exist all over the place. That's not the problem. The problem is when they exist and they're unidentified or untreated. And so I think identified, treated mental health or substance use issues can be very well negotiated between the families and whatever resources they're using. Unidentified and untreated issues of abuse, substance, physical, mental, sexual abuse, and other mental health issues, that's often what the court gets in the percentage of cases that go to trial. And all gloves are off in that.
For sure. And I think, as you mentioned, Carrie, the toughest part is when, you know, there is some level of dysfunction for whatever reason. You know, like you hear from clients all the time that they believe their spouse is narcissistic, or, you know, and that's like a kind of a favorite word these days. But, you know, that's the kind of dysfunction where you're not going to just treat it with some sort of rehab, or you're not going to take some medication and treat it. So those are, you know, there are certain things that we hear all the time. And the key becomes like, how do you, if you have to go to court, how are you communicating that to the court? Because how are you educating the court? Like, I think this is something that you need to hear, court, that's going to affect my kids and my parenting time. Because when the courts look at every case they look at, there's statute involved, right? And the law in Michigan says that parenting time has to be granted in a way that's in the children's best interest. But there's a strong presumption that it's in a child's best interest to have a strong relationship with both parents. So I mean, you could probably get parents to agree to that, right? Oh, I do. I want what's best for my children. So it's not as easy as just saying what's in the children's best interest. We have to really evaluate what that means. And then when you say, we presume that it's in the child's best interest to have a strong relationship with both parents, I think for some people that automatically means, well, that must be 50-50, right? Like, I want a strong relationship, you want a strong relationship. So let's just be fair and do it equal. But I think to really answer that question, the court looks at these factors, and kind of the distinction that Carrie and I want to talk a little bit about today is the court really getting to what's best for the children and when they go through this analysis. So there's 12 best interest factors, and we'll talk about some of those in detail today, and kind of the limitation of those factors as the court uses them in kind of the actual application when it applies to your kids. So, and we're also hoping that maybe by discussing some of these factors, you know, if you are going through a divorce or thinking about a divorce, that you know how to even convey to your attorney, these are some of the issues, because the legal system will look at some of this, but at the end of the day, when you're actually in court, there's things you can share with your therapist, or a therapist like Carrie, who's maybe doing co-parenting therapy. She can hear everything, but a judge can't necessarily hear everything. So the judge is limited. They're a trier of fact, a finder of fact, but they're limited by the rules of evidence, right? And so I think, Carrie, I'm sure you can attest to the fact that a lot of what you hear from parents is something that they've been told by their children.
Absolutely. Right? And I'll tell you what, I used to be a family law attorney. And so one of the helpful things for my clients is that I know the rules of evidence. So I have the opportunity to sort of prepare people for the eventuality that the thing that's most important to them, that their child told them, the recording they have, all of the things that they've heard actually aren't admissible in court. And I'll tell you, even as someone who used to practice law and knew the rules of evidence pretty well, it's tricky. It is really tricky. And so that piece often becomes a really, really diminishing, you know, like it just feels like a loss of power when you aren't able to tell the court the thing the court really needs to know, because it's just not admissible evidence. I think I want to kind of throw in one little piece that I forgot to mention, is that I think, I don't know, Shalini, correct me if I'm wrong, but I feel like part of the 12 best interest factors, maybe not deliberately, but effectively, not only help to understand sort of, how these parents parent, but I also think one of the really important things to do, and I'm sure you do it, Shalini, in your practice, I do it in my practice, is distinguish between a terrible spouse and a decent parent. Because many relationships break down because the marital relationship is terrible and people behave horribly, as people will do in times of crisis or in times of conflict, but can still parent well. And I think that is part of what the court is trying to get through is, okay, you did terrible things in your marriage, but are you still a good enough parent? And
I
use
hear
the
that
term,
all the time.
yes. And I use the term good enough as opposed to great or excellent or, the better parent, because I do think at the end of the day, and this is really hard for families to hear, is that when it comes time to parenting, particularly with the presumption that a lot of jurisdictions have, that they want to encourage relationships with both parents, that good enough is good enough. And for the excellent parent, relinquishing a certain percentage to a good enough parent can be incredibly heartbreaking. And that's where the emotional and the legal have a really hard time coexisting.
You are a great explainer.
She really is. And that is unfortunately, I think, a reality that the sooner a client understands, probably the better, because I think parents often look to the legal system for like a sense of justice, like, okay, like the court's going to do the right thing. And first of all, what you think is the right thing versus what the court thinks is the right thing, or frankly, what Carrie thinks is the right thing, could be different. And yes, the court is often looking for good enough, right? So it's not an ideal. They're not looking for some ideal standard, but is it good enough for the kids? So within that, often it's difficult because I do think that at the end of the day, perhaps your children are suffering to some extent. And so, is there a way to craft a schedule that really is great for the kids? Maybe not ever, right? Because at the end of the day, parents decided to get divorced, right? So now the kids are forced, like I don't have to live in two separate houses. Like the mom and the dad get to live in their house, but the children are the ones who have to go back and forth, right? They have to make sure their stuff is in mom's place and at dad's place. And if mom and dad aren't getting along, that's just making it all the more difficult for the child. Mm-hmm. So this whole art of crafting a schedule, I think, should probably take more effort than it sometimes does. But the court, again, has limitations. And so we wanted to talk a little bit today about some of these factors and just point out kind of the disparity of analysis, I guess, that can sometimes take place. So for example, and as I mentioned, there's 12 best interest factors. So real quickly, factor A is the love, affection, and other emotional ties existing between the parties and the child. Factor B is the capacity and disposition of the parties involved to give love, affection, and guidance, and to continue the education and raising of the child in his or her religion or creed, if any. C is the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, or remedial care. D, the length of the time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. E is the permanence as a family unit of the existing or proposed custodial home or home. F is the moral fitness of the parties involved. G is the mental and physical health of the parties involved. H is the home, school, and community record of the child. I is the reasonable preference of the child if the court considers the child to be of a sufficient age to express the preference. And we're not going to talk about that factor, but I will just state that typically if a court is interviewing a child about this preference, the parents are not involved in that, and the parents do not hear about what the child said, because we want to try and protect the child's thoughts, and we don't want the child to feel pressured. J, the willingness and ability of each of the parties to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent. K is domestic violence. And then there's kind of a catch-all. But as we talk about these factors, it's important to note that when a court is evaluating these factors, both sides will present evidence. And then the court literally evaluates the factor and says mother is favored or father is favored, neither is favored, both are equal. And the court does literally add it up at the end of the day. Like, okay, mother got like 6 factors in her favor and father got 4 factors in his favor, and there's 2 neutral. And so they try to make it formulaic, which again, inherently is somewhat of a problem, right? So just by way of example, let's look at factor A, the love, affection, and other emotional ties existing between the parties involved in the child. Now, when the court looks at this is often like a very broad brushed factor because of course the parents love the child, right? Like you might ask your client if they're like testifying, well, how does your child show you love and affection? How do you show your love, child, and affection? Like, what's your relationship like with your child? How do you spend quality time together with your child? These are pretty easy things for a parent to answer, right? Like, of course I love my child. But Carrie, talk to us a little bit about why that factor can sometimes be misleading or why it's overlooked.
This is where, you talked a little bit about justice before. And one of the conversations I have with a lot of people is the distinction between just, as in justice, and fair, which is justice is a legal requirement. You will have, your opportunity to be heard in court. You can have representation. Fair, that's not the court's job, right? So they're adjudicating. They're trying to find justice by actually giving appropriate consideration to each of these factors the best that they can. So look at factor A and think about this scenario. One parent has been more of a stay-at-home parent, more available to the children, more sort of boots on the ground, the all-day involvement, a lot of the extracurricular involvement, a lot of the scheduling. And somebody has spent the last 10 or 15 years providing for the financial stability of the family, whether it has been elongated education or residency or long work hours or, night shift. And so if you look at factor A, and a lot of the sub factors are who was the child bonded with, who does the child go to without a problem, it can factor one parent because that parent has been, per the marital contract, what you decided when you got married. You do kids, I'll do money, and we'll put it all together. Perfectly legitimate marital contract. In divorce, one of those parties is not really favored in factor A because that wasn't part of the marital contract. And so the question is, the court can look at that and say, okay, we favor parent A because parent A is more bonded with the children, has been more present, has been more involved in the activities and in the soup to nuts care for the children. But can't parent B be prepared for that? Can't parent B become a part of that in their own household? And I think that this is really where a lot of conflict comes in, which is, yeah, I didn't because I was doing the other thing that needed to happen in our family, which was make the money. And so factor A often favors the parent that both parents agreed would be around more. But how does that bridge the gap in divorce to the emotional aspect of preferencing relationship with 2 parents and maybe allowing a second parent to be readied, or take into account that this role of being the breadwinner in the family is also really important. And so I think that's where the emotional and the legal kind of,
I guess even beyond that though, Carrie, because really what I was getting to was sometimes this factor to me, I don't feel like the court actually gets to the heart of it because you're talking about, oh, sure, I love my kids. I give my kids hugs. I give my kids kisses. And regardless of their roles, I think both parents can like kind of be very equal on this. But I'm sure you've seen situations where what if you're dealing with like a parent who is actually like overly loving of their kid, right? Like maybe the child, maybe they're suffocating the child with like love bombing and things. And like those are,
we call that enmeshment. Exactly.
Enmeshment.
Enmeshment, right? Where the love, affection, and emotional tie between the parties favors a parent, and it's very unhealthy. So exactly, that's where, the legal analysis can be very straightforward and very, because a lot of like, I'm looking at some sub things that come up a lot, like the bonds. Who does the child prefer? Who's the one that the child will choose? How does each parent relate to the child? And that is not always healthy to your point, Shalini, it's not always a healthy bond, even when the bond favors one parent extraordinarily. And it can be very exclusive of another parent who's tried very hard to establish boundaries and hasn't had a voice. So yeah, I think that is the difficulty, is that the court can't necessarily look at the totality of the nuances of the relationship. I think that pertains to a lot of the factors where there's an argument to be made based on facts, based on family's experience, based on the family's homeostasis. But divorce challenges and breaks that homeostasis. And so what are the court's limitations in understanding the nuance, the patterns, the role of extended family, the role of boundaries, and all of the things in a family that may on paper look functional, but in reality are actually dysfunctional and don't support a restructuring that leads to healthy relationships with both parents. So I think the short answer to your question, Shalini, is nuance. Court doesn't do nuance.
And what about, like, sometimes you have the parent that always helps with homework and does the bedtime and getting ready, and then you have the parent that goes out to dinner and does all the fun stuff. You know, and both are important, right? You need both, but one might be favored to a child more than the other when they're younger, or the parent who is mostly taking care of the children now has to go work and manage a household. So now they have to balancing that they have to do that they didn't have to do before. And that obviously could change the structure of the emotional wellness of the family, right?
Well, and that's where a lot of the rub comes in, because, you know, the court does favor structure or stability and predictability for children. So I think the parent who has been that stay-at-home parent often comes into this process assuming, well, that's just what I'm going to continue doing. But that's where kind of the concept of what Carrie introduced is, now we have to define two different companies, right? Because yes, the parent who was at home may need to spend more time out of the home now, and the parent who wasn't will now step up and hopefully change the role that they had in during the marriage, right? And the courts, for the most part, are giving parents those opportunities now. Like, the court is understanding of the fact that just because you were the breadwinner doesn't mean that that's going to always be your role. I think where the gray area sometimes comes in is, I think sometimes courts are like overly considerate to the parent who wants to step up. The question becomes, can that parent step up? And while that parent is trying to step up and learn maybe new skills, are the children kind of falling through the cracks? Because yes, we want to give that other parent the opportunity to do those roles that maybe he or she didn't do. But in the meantime, like, the kids are not used to looking to that parent for that stuff. And they kind of are used to looking to the other parent. So I think explaining that to the court, or getting to, hey, this is how the child is actually suffering while we're allowing this other parent to take on this new role. I think that's where a lot of your work ends up coming in, Carrie.
It is, and it's, you know, I in my head right now, I'm thinking, like, how does it get to this place, right? How does it get to this place? What's sort of the genesis of, like, when we say really try to manage this on your own and stay away from court? And I think that what happens is, when people make the decision to divorce, you want to separate. You want to separate. Like, why wouldn't you? It's enough. You've made this decision that you don't want to be together anymore, and now you want to separate. And in order to separate, no one's leaving the home without a parenting plan. And so oftentimes parenting plans are either constructed in crisis because the parents want to separate, or they're created by third parties who don't really have a deep dive look into the family in order to get the family separated, because you really aren't going to leave your home unless you have some sort of financial agreement and some sort of parenting agreement. So the one thing I would say to your point, Shalini, is I wish this process could slow down, right? People in crisis don't want to move slowly, but if this process could slow down and these things could be taken into consideration, people could build more sustainable parenting plans that take into account the developmental needs of the kids, the difference between a 3-year-old and a 12-year-old in the same family, making sure no one gets parentified while skill building is happening, right? There's incremental build. There's, okay, you haven't been around your parent a lot because your parent isn't typically home during the day. Let's spend some time doing that, build these skills, work together to sort of understand that even if it's the hardest thing, which it is, parents will ever do, is understanding that if they work together to support the needs of the children, it will also be the most amazing thing they ever do. And so I think that one really big hurdle that families have to jump in divorce is that to separate, you have to do the legal stuff. And that could take thoughtfully months and months and months, and separation needs to happen yesterday. So I don't know how much you come across that, Shalini, but that is a pervasive theme of, I can't do this anymore. We need to separate. How do we get out of here? And then we build parenting plans that just aren't able to take into account all of these needs. And so people are in court for years and years and years trying to litigate emotional concepts, right? This person doesn't cook balanced meals. This person never does bedtime. This person's terrible at homework. This person's a screamer. This person is always late, right? These are the kinds of things that kids have to deal with. And the only forum for parents resolving it is court. And how is court going to make a punctual person, a non-punctual person punctual, right? Or how is court going to teach somebody nutrition when they just don't care? So,
and these are perfect examples of kind of what we deal with. And even though we keep talking about don't go to court, there are other alternatives. There are other professionals, GALs, therapists, parenting coordinators, co-parenting therapists, and I'm sure we'd be happy to talk about those in another podcast, because we don't want to leave people feeling like, okay, you don't want me to go to court, so then what do I do? Like, how do we get past this? And so there are alternatives. And Carrie and I would be happy to talk more about that, but I know we were trying to limit today's.
I want to hit the 12 different steps that you talked about, because they're so interesting. And I talk to people all day long who are going through divorce, and I do hear a lot of the things that you're saying, and I never put them in perspective of the court and the legal. And I do hear from stay-home parents a lot about their overwhelmment and not liking how the other parents, and then them having to go find a job, and they think they should be home with the kid. It's just a lot of juggling. So if you too are interested, I would love to schedule a part 2, and I'm wondering if maybe we need a part 3. But I think these are all really, really important topics that I would like to continue discussing.
of course.
Oh, good. So just to wrap up for today, and I thank you both, incredible amount of information. And I loved having both of you kind of pitch in. That was like a great thing to do. If I have someone who wants to get a hold of you because they have these issues and they need a mental health professional or a legal professional to discuss them with, Shalini, how do they get a hold of you first for the legal part?
Well, I think the best way to probably reach me is my email address, which is S as in Sam, H, N as in Nancy, A, N as in Nancy, GIA at varnumlaw.com. And Varnum Law is all one word, VARNUMLAW.com. My phone number is also 734-372-2928. So yeah, probably the best ways to reach me.
Wonderful. And Carrie, what about you for mental health?
So I have a platform called, it's Divorce Beyond Court, which does exactly what we're talking about today. Takes my legal background and my mental health background and sort of helps people to bridge the gap, understanding a little bit of both, and help, it's really coaching about everything we talked about today. So for that service, I can be reached at Carrie at Divorce Beyond Court. And Carrie is CARRIE. And my phone number is 203-246-2002.
Wonderful. I thank you both so very much.
Thank you.
Thanks. I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.